Here's a conversation that I have regularly with partners at large, well-capitalized, nationally recognized law firms. Attorneys who, by every conventional measure, are in excellent positions. And the conversation goes like this. They've built a strong practice. They have real client relationships. They're well compensated, but they're not happy, or they could be happier. Something just feels off. And when we dig into what that something is, it usually comes down to a version of this. The platform they're on is either too large, too bureaucratic, too difficult to let them actually do their best work. They're paying for infrastructure they don't use. They're navigating internal politics that don't serve their clients. And they're increasingly aware that there's a different model, maybe something smaller, more focused, more nimble, that might actually fit them better. Maybe with a bunch of expats from large firms that decided they wanted something different and maybe something a little bit better and more collegial. They didn't need 1,000 corporate attorneys. They just needed some really good ones. They didn't need a big litigation department. They just needed the scale in case things get out of hand a little bit, or they just needed some competence in that area, maybe some high-end people. I'm Andrew Wilcox. I've been a legal recruiter since 2003. Today, I want to talk about boutique firms, when they make sense, why they sometimes outperform BigLaw for certain types of practices, and what you need to think about honestly before you make a move from a platform with global reach to one with a very different profile. So let's start with what boutique actually means. The term boutique firm covers a lot of ground. At one end, it's a single practice area firm. Think litigation boutiques, IP boutiques, employment boutiques that do one thing extremely well and don't attempt to be anything else. At the other end, you have mid-size, multi-practice firms that operate regionally or nationally, but are smaller and more focused than the AM Law 100 giants. And in the middle, a range of firms that combine specialized excellence with selective adjacencies. What they all share is focus. A boutique firm, by definition, has chosen not to be all things to all clients. That choice creates both advantages and limitations. And understanding which matters more for your specific practice is the central question. So let's talk about the case for boutiques, when the model wins. Boutique firms outperform large platforms for certain types of practices in specific, identifiable ways. So let me walk through them. The first one, when your practice doesn't need the full service model and you're tired of subsidizing it. Large firms operate on cross-subsidy. Partners in high-margin practices subsidize partners in lower-margin practices. Partners who don't need international offices subsidize the cost of maintaining them. If your practice is self-contained, your clients need what you do, and mostly just what you do. You may be paying for a platform you are not using. A boutique firm prices its overhead to what you actually need, and the economics can be significantly better as a result. The second, when speed and flexibility matter more than institutional depth, boutiques can move faster than larger firms. Fewer layers of management, fewer layers of bureaucracy. If you need to get marketing budget, sometimes you can just pick up a phone and call Al down the hall. That doesn't happen at a lot of large firms. There's fewer committees, fewer sign-offs. If your clients value responsiveness and entrepreneurial decision-making, a boutique structure often delivers that better than a platform where every decision runs through multiple levels of firm governance. And I'll say this as a recruiter. How a firm does talent management is how they do most things. If it's bureaucratic in talent management, it's going to be bureaucratic when you ask for marketing dollars, when you ask for support, and everything else. So something to keep an eye out for when you're evaluating a law firm. How bureaucratic and how well do they invest in just the talent management and the recruiting process? 3, when reputation in your niche is what matters, not a general brand. In certain highly specialized practices, the boutique brand is often stronger than the BigLaw brand. A top-tier securities litigation boutique, a nationally recognized environmental boutique, a preeminent labor and employment firm. These firms own their space in ways that make the general prestige of a large platform largely irrelevant. If you're in one of those practices, the boutique name may actually open more doors. Fourth, when culture and collaboration are genuine priorities. Large firms talk endlessly about culture. Some of them have genuinely excellent cultures, but many don't, because culture's hard to sustain at scale. What are they doing about that? Boutique firms, when they're well run, can create cultures of genuine partnership and collaboration that are structurally easier to maintain when everyone knows everyone and the economic model rewards collective success. Fifth, when you want equity, governance voice, and direct control over your own trajectory. In a boutique, equity tends to mean something real. You're not one equity partner among 400. You're one among maybe 20 or 40. Your voice in governance matters. Your compensation is more directly tied to the firm's overall performance and less mediated by complex allocation formulas decided in a room somewhere. For attorneys who want genuine ownership rather than just a title, boutiques often deliver that. Now, let's talk about the case against. When BigLaw wins. Boutique firms also have genuine limitations that need to be acknowledged. And the first one is cross-selling and adjacency work. If your clients routinely need capabilities outside your primary practice area, seems obvious, right? A boutique that doesn't have those capabilities creates friction. You're referring work out instead of keeping it in-house, which could weaken the overall relationship over time. Large platforms win when the client's legal needs are genuinely multidimensional. The second one is geographic reach. If you practice nationally or internationally and you need boots on the ground in multiple markets, a boutique with limited geographic presence creates real constraints. BigLaw's geographic footprint is expensive to maintain, but when you need it, there's no substitute. And then having brand in certain client markets. Some clients, particularly large corporate clients, institutional clients, clients who themselves operate at massive scale, have a preference for working with firms that match their institutional profile. Nobody ever got fired for buying IBM, remember? The Fortune 100 general counsel hiring outside litigation counsel may simply have a default preference for AM Law 50 firms. And breaking through that preference as a boutique, however excellent, can be difficult. Resources and financial stability. Boutiques are leaner, which is an advantage until it's a disadvantage. If a significant client doesn't pay, if a major matter concludes without immediate replacement, if the practice has a down cycle, boutique firms have less cushion. Large firms can absorb those fluctuations more easily. The trade-off is stability versus efficiency, and which matters more depends on your risk tolerance and your practice trajectory. So the questions you need to ask before you move to a boutique. Is the boutique genuinely excellent in its area? Or is it a small firm that's calling itself a boutique for branding purposes? The real boutiques, the ones that justify leaving a large platform, are the ones with genuine market-leading reputations. And you need to verify that independently. Does the boutique's client base overlap meaningfully with yours? And do your clients actually need what the boutique does well? If the boutique is known for one thing and your practice has grown to include adjacent things, the fit may not be as clean as it seems. Third, what does the economic model actually look like? Boutique economics can be spectacular. You're getting a much larger share of what you generate because the overhead is lower. But make sure you understand both the upside and the downside. What happens if your book has a tough year? Fourth, who are the other partners? You're going to get to know them really well. And are these the people you genuinely want to be in business with for the next decade? At a large firm, you're somewhat insulated from partners you don't love. At a boutique, you're all in it together. The quality of the partnership matters enormously. Are these your people that you want in your foxhole, or do you want to run from them? And vice versa. The timing consideration is huge with this. Moving from a big law to a boutique is often most successful when your practice is genuinely established. Maybe you don't need all those resources. You've identified the resources you don't need. So a small or a boutique makes more sense. When your client relationships are deep enough that the brand you're leaving doesn't materially affect them, or when the market reputation is strong enough that you can carry it with you. When your origination is real and portable. If you're still building, still developing your book, still establishing your reputation, still relying on the platform to generate opportunities, the move to a boutique may be premature. It's a conversation I have all the time. Sometimes the best advice is waiting and building. For the right attorney, with the right practice at the right stage, a boutique can be the best decision they ever make. For others, it's a loss of platform they didn't realize they needed until it was gone. Know which one you are before you move. I'm Andrew Wilcox. This has been The Lateral Brief. If you'd like to have a confidential discussion about you or your career goals, please reach out to me at andrew@wilcox-legal.com. As always, grateful, Andrew Wilcox.